will each one of these audits, is each one of these essentially a compliance audit in itself?
Yes.
And if there should be a repeat offender, what happens on the other end? If you've got somebody who has lots of findings against them?
Yeah, we don't have any way of, there's no penalty for being a repeat offender. I suppose theoretically that might become a risk factor downstream. That you could end up warranting a closer look during our normal annual audit.
Would your findings be binding in any way?
Our findings are not binding in and of themselves. However, under the law, an audit finding has a presumption of validity. Having been a prosecuting attorney and represented local governments, I would not want to have the lawsuit where Exhibit A is the auditor's determination that my client failed to comply with the law. Yes, sir.
Is there any other system in the state where you can do this? It's ringing a bell that this has been done or tried before, this mediation process ahead of the lawsuit.
Well, the mediation is currently done for local governments in the Office of the Attorney General. This is not, what I'm proposing, or actually implementing today, is not a mediation. It is a determination of compliance with the law. And I suppose I should mention this. We think of audits as being something that's done with papers and finances. But in Ohio, under the law, an audit is actually much broader than that and can include the determination by the auditor state whether a government is complying with the relevant statute that applies to that office. For those of you who are interested, did we hand out that statute? Brittany? No, but we can get it to you. It's 11701, and it's down B2, I think. Anyway, we can get that to you if anybody's interested in diving that deep.
Is there any sense that this could be a step before people might go to the Attorney General's office?
For local governments, we will not consider this until they've tried the mediation. If people can sit down, work it out, that's much preferable to spending resources to make a determination.
And this would not be related in any way to a court-ordered mediation, right?
No.
You mentioned this can be done with existing resources. Do you have any predictions on how many complaints you might actually have to take on?
You know, we tried to figure out whether there was some source that we could use to extrapolate. There really isn't. Because right now, if I was going to say the average citizen, but beyond that, the average media outlet these days gets stonewalled, there's very few places where the dollars for a lawsuit are justified. So what happens if somebody stonewalls? Nothing. We complain about it. We maybe write about it if it's news media. If it's a private citizen, you never hear about it. So I have no way of knowing really how much use this program will get. But a year from now, I'm going to let you know what we saw that first year.
Do you know the average cost of how much it would cost to take something like this to court? How much money it would be saving?
Like any lawsuit, it's difficult to say. They can be expensive or really expensive. I can tell you that I had a case when I was Delaware County prosecuting attorney that I inherited regarding a township from another lawyer where the billing for the plaintiff was $250,000. Now, my sense is that $25,000 to $50,000 is probably more close to the ballpark, but I'm sure each of you can check with the lawyers for your media outlets and find out what your experience is.
Would your final decisions as a result of the audit actually be an audit finding? And would there be a way for the losing side to appeal that in any way?
Because there's no enforcement mechanism for my office, there's no need for an appeal. And now you're asking a lawyer question, and I'm sitting here wondering whether an administrative appeal under 2506 might apply. I don't know.
But this would be an audit finding.
But it would be an audit finding, yes.
Can a compliance audit get to sort of subjective things like overly broad, which is a lot of what people run into when they ask for documents and are denied?
And overly broad is what's being litigated a lot in courts right now. We have relatively limited guidance on that. Our office is going to try to help develop some of the guidelines for that. So I expect that we will be asked to talk about what's overly broad and what's not, and I think it'll be a huge benefit to the state if one of our findings eventually is tested in court and we get from the Supreme Court definitive guidelines on what constitutes an overly broad request. We don't have it now.
Dave, one of the gaping holes in both the Attorney General's mediation program and what you propose here is the lack of any action toward being able to pursue a complaint outside of court against state government, public universities. Does Ohio need a public record ombudsman who could issue binding rules?
I'm for anything that would provide a simpler, non-litigation based resolution mechanism. The beauty about what I'm suggesting is that it has the presumption of law. We don't need any legislation. We can do it under our existing authority.
Would you be